You all set, Jeff? Okay, welcome everybody. I'm Cynthia Young, the supervisor of the town of Malta. I want to tell everybody there are 2 exits in the rear of the building, and in case we need to evacuate, this goes into my office and then out into the hall. That's a closet, so don't go that way. Some people are getting sick of hearing that every time, but we are here tonight to have a hearing on the alleged code violations for the Steeplechase apartments here in Malta. So with that, I'd like to ask our visitors to introduce yourselves. As I say, I'm Cynthia Young.
Good afternoon. My name is Jennifer Yetto with Whiteman Osterman and Hannah on behalf of SL Malta Apartments. Here with me I have Anna Patras and Tim Tracy on behalf of SL Apartments, my colleague Will Nolan, also with Whiteman Osterman and Hannah, and Connor Ross with Rand Fire Protection Engineering.
Maybe it would be helpful if they stood up there.
Yeah,
Within the future when they talk, they will. So,
Well, I'll introduce myself. I'm Al Rickey, councilman. How you doing?
I'm Barbara Connor, member of the town board, and I have a request when we speak. Can we have them use the microphone, please? Thank you.
Craig Warner, town council.
so I think we're going to start with a general synopsis from Stephanie Bitter. Or,
No, I'm Steve Gottman, I'm the town attorney. We are also here, special counsel for the town, Stephanie Bitter. We're prepared to proceed with the hearing. I know there were some discussions about potential stipulation, but I guess it's not proved fruitful, is that correct?
I think the terms of the stipulation that were sent to my office were different than the terms that have been discussed with the town. So for that reason, we're still open to discussing a stipulation that's in agreement with what Mr. Bird had seemed to agree to at our meeting last week. And otherwise, we'll present our case and preserve the record.
Okay, otherwise, I think, Jen, I just wanted to verify before the hearing began that you did post and mail notice as required by statute and the notice of hearing, correct?
correct,
And you have copies of those here today?
correct.
All right. Okay, I'm satisfied. Thank you. Stephanie.
Okay. Good evening. I'm Stephanie Bitter, special counsel. I'm here with Greg Berg as well as Rob Agnes. Is that how I say it? Fire marshal, code enforcement officer. They're an important part of this story, but I'm going to provide you the timeline as well as the supporting documentation. As Steve Gottman had indicated, we did have an understanding to a certain extent. We provided a proposed stipulation, but essentially we want this to be concluded as soon as possible. So the apartments at issue have 235 total apartment units. Is that correct, Greg? And the number of buildings roughly? 24 total buildings. The Town of Malta regulations have a third party performing inspections for the fire protection systems. That fire protection report is then submitted to the town. Our story begins in May of 2022. Northeast Fire completed that inspection report and violations were noted, specifically on pages 18 and 19, and then outlined of deficiencies from pages 20 to 36. I will submit all of these documentations as we conclude the narrative. Northeast Fire is here today if we have any questions as to the details of that report. Subsequent to those deficiencies being identified, they were identified to the property owner. The Town of Malta followed up with them specifically in June of 22, and again in July of 22, asking for any update as to the status of those deficiencies. They asked again in February of 23 and March of 23 as well. In August of 23, Absolute came in and completed the second annual inspection. That was conducted on August 22nd, 2023. That report outlined how many deficiencies, Greg? 104. The number of buildings at issue? All of them. And again, the number of units affected? 235. There was communication with the town in Steeplechase in September relative to that report, but there was no indication of when those repairs were going to occur. So on November 21st, 2023, Rob, the fire marshal, issued an order to remedy. That order to remedy provided 30 days. Thank you, Rob. Rob had suggested during that 30-day period to implement fire extinguishers because he was very concerned with the tenants and their safety. So in December, Rochelle, I cannot say her last name. Anybody? Thank you. She is the new property manager. She begins communication with Rob. She indicates that she understands this is a time-sensitive matter. They've reached out to multiple vendors, and they're aware of violations. Again, these will be emails that will be part of what we submit to the town board for their review. On January 12th, they reach out to Rochelle again, and Linda Kirks, I think she's also something relative to operations. The work was supposed to get started in the beginning of January. It hadn't, so Rob had reached out to him to get another update. At that point, they responded by saying that the leasing manager, because Rob actually went to the site, I believe, that day, the leasing manager indicated that they were waiting for an approval to move forward with the repairs, which I understood, or Rob understood, to be an approval from corporate. On January 12th, there was an email from Tim Tracy, who I understand is the director of operations, that they were moving forward looking into vendors. We had asked if Absolute had been engaged for the repairs because Absolute had done the report that was issued in August of 23 outlining the deficiencies. We confirmed in January that Absolute was not engaged. They were not assisting with the repairs. They were not the vendor that was addressing it. On January 25th, Anna Pratras and I had communicated, and I asked what the status was. There was a concern that the fire extinguishers were being removed from the units. She had confirmed that they had not. She said they were still evaluating vendors, currently working to engage a fire suppression vendor and to undertake the repairs. Like I said, she confirmed that the fire extinguishers were still in place, and she requested that they be able to phase in the replacement of the antifreeze in the buildings. At that point in time, I didn't receive a timeline, nor did the town hear anything further other than that request. February, we don't hear much of anything. There is rumors on the street that Above and Beyond are retained, but we have no confirmation. That's another fire suppression system company. In March, we reach out and indicate that we're going to have Absolute go back in to re-inspect. Because at this point in time, we're not sure if the fire extinguishers are there, and there is uncertainty of what repairs have actually been done, since again, we don't have confirmation that any vendor has been retained. So when we don't hear anything, we communicate with the attorney. The attorney responds to confirm that they are working with Above and Beyond, which is a contract to care for some of the work. There was only a few buildings that they were working on. And they, again, want to discuss phasing. But they don't provide any proposal as to when that phasing would occur and the timeline associated with that. So on March 18th, we ask again for a confirmation that a contract is in place and that payment has been provided to Above and Beyond so that we don't have to move any further. On March 20th, we are advised that there's a delay in their payment, but they're working on it. At that point, they identified that buildings 21, 23, and 14 were being worked upon. But again, there's no suggestion of a timeline, no understanding of when this will be over. So a court action is commenced in which we bring it to town court with the idea that we want to leave it out of the public so that there isn't concerns so that we can try to make an arrangement since there was this identification of a timeline. There was a motion to dismiss, and essentially they wanted to procedurally handle it in the fashion that we're handling it tonight. We met on May 15th. We were provided a contract of their proposal. Again, no defined timeline. And we asked for them to execute a stipulation. That stipulation to identify that it would be concluded by August, and if not, that there would be boots and suspenders associated with that stipulation. In sum and substance, that the town could go in and fix it so that we wouldn't have these tenants now in another winter season with the actual issues at hand. I'm gonna have Greg and Rob come up and just outline what the issues at hand are in a simplistic manner.
The issues at hand are they're basic maintenance items, but more importantly, it was the issue with the antifreeze systems being unlisted within the buildings. As my understanding is, 4 have been taken care of. Rand, I believe, is going to be doing the inspections of each of the buildings so that we know that, for certain, everything's been done. And I do believe that Northeast did take care of 2 more prior to their leaving their service.
So what total number of buildings have been remediated?
6.
6?
6.
Thank you.
And then, I was provided with the sheets for the type of antifreeze that was used. It is a listed antifreeze, so that's okay as far as I'm concerned. The rest of it is just basic maintenance items. Everything from sprinkler heads to leaks to different items such as that. They were all noted in that particular report in 2023. So that's about the size of that.
So Greg, if I can ask, what is the implications or the danger of having this unlisted substance in the sprinkler suppression, the fire suppression system?
Okay. The unlisted antifreeze systems, some of them actually separated. So that, and there's 2 different types that I'm aware of. One is glycerin base and one is glycol. This particular system is glycol. And when it reaches a certain percentage of separation, it can become flammable, and under certain circumstances, with a certain amount of heat and a type of sprinkler head, it could also cause an explosion. A number of people have died. There are 5 reports that were extensively studied as to this type of danger, and subsequent experimentation through the National Fire Protection Association when they did more testing to figure out why this occurs and under what conditions. And to be quite honest, in home fires, it could easily happen, and it has happened. So in this case here, this is an unreasonable situation that it's in, and we really don't know what's actually in each one of the systems, in each one of the buildings or the apartments.
So you said that there were other violations. In your opinion, is this the most serious?
The other violations are basically, they're along lines of maintenance, okay? Systems need to be maintained. Code does state that. Everything needs to have a certain amount of maintenance applied to it. For instance, sprinkler heads do age out. All right, when they do, you change them. And those types of things. Leaks need to be addressed. So those types of maintenance items are the ones that were most frequently noted.
Any of my colleagues have any questions? And so I do have this fire inspection report that says that they were supposed to be remedied by 9/20/22. So that was just ignored?
I would say yes.
Because now that's almost 2 years ago.
Yes.
I'm going to hold off until after I hear from Steeplechase first. I'd like to hear their comments first before I ask questions or comment.
Okay.
I'd like to hear both sides of the story first.
Any other questions? Okay.
Just want to acknowledge, though, too, sprinkler system's got to get inspected how often?
Annually,
Annually? From a fire inspection.
yes, from the Fire Inspection Agency, yes, fire suppression.
So in your opinion, this not only represents a serious hazard to the residents there, but this is also, the fire protection is provided by our volunteer fire protection, volunteer fire company, so, but in your opinion, it's also dangerous for firefighters to go in there and try to,
We don't know what's going to come out.
right?
We just don't. Could be fine, but it's kind of like playing with Grandpa's old World War II hand grenade, and somebody says, "Oh, it's been diffused." Yeah, I'm not pulling the pin.
Any other questions? Anything else from,
I was just outlining here the communications that I referenced in my presentation, and I'll show you it there in just a second. This is Northeast report. These are the correspondence in 22 that the town had looking for any additional information. This is Absolute's report. This is the order to remedy. Further correspondence from the town looking for any update. This is responses as to where they stood after the 30 days had passed in the order to remedy timeframe. Communications in January. Absolute advising that they're not retained. Anna Patra's communication relative to that they want to do a timeline and phase it. This is communication as to we wanted to re-inspect. Additional correspondence indicating that they had retained above and beyond. And then the next course of action was at the town board, but that was the communications that we had thus far.
Thank you.
Greg, just, you previously presented this information to the town board 2 weeks ago, correct?
Yes,
And at that time, you recommended to the town board that this property was in an unsafe condition, that it posed an unreasonable risk of fire in violation of section 630A of the town code. Is that correct?
yes,
And there's been some correspondence and discussion with Steeplechase Apartments, but again, your recommendation to the town board is still the same, correct? That it poses an unreasonable risk of fire?
yes, at present.
And secondly, that it needs to be corrected in a timely fashion, correct?
Yes.
All right, thank you. Do you want to have any questions for Mr. Berg, or you want to just put a presentation on afterwards?
At this time, I don't have any questions for Mr. Berg. Thank you.
Okay, you're welcome.
All right.
Can we reserve the right to ask any questions?
Of course, yeah, you're welcome. Thanks, Greg.
Rob, do you have anything to add, or?
May I?
Yes, please.
Members of the town board, I'd like to thank you for the opportunity to speak to you today. As I mentioned, my name is Jennifer Yetto with Whiteman, Osterman, and Hannah, and here with me I have my colleague Will Nolan, and I have Tim Tracy, the Director of Operations for Steeplechase, Anna Patras, General Counsel for the Silverman Group, and Connor Ross with Rand Fire Protection Engineering. I just want to start at the outset with mentioning that Contrary to what the town may have noted in its paperwork and in its commentary, we very much are concerned about our residents as much as anyone else. We care about their safety, we care about their well-being, and we want to do right by our residents at Steeplechase. There are a few points that Ms. Bitter made in her presentation that I just would like to clarify. She is correct that in January of 2023, we had asked the town if they would be willing to let us phase in the work several buildings at a time. We did not get a response to whether or not that would be permissible. We were told that if we did not do X, Y, and Z, that the town would remove our certificate of occupancy. So we aren't even at the position in January of 2023 to propose a schedule of work if we don't know if the town is even willing to let us phase in the work over that period of time.
So you thought it was prudent to not do nothing?
No,
Because you didn't have the
actually.
town's approval to do corrective deficiencies way back in January?
No,
You
sir.
needed approval, you already got the code violation of not complying.
No, sir. Actually, in February was when we had contacted Above and Beyond. And since that, despite the town not responding to whether or not we could phase in the work, we contracted with Above and Beyond, and they did perform the first batch of remedial work. So Mr. Berg is correct that that work was performed in several buildings at our property. You also heard reference to the meeting that we had last week to discuss a proposed resolution. What is very critical about that meeting is that we have contracted with Above and Beyond to have the work performed at every single building on our property that remains in the condition alleged. We are working with 19 remaining buildings, and we have a contract. We made the first payment. And at our meeting with the town asked us for a date certain by which the work could be performed. As we sat here with the town, we did not know when our vendor could agree to complete that information. That same day, we sent an email to our vendor and we copied Mr. Berg on that correspondence. In that correspondence, our vendor informed Mr. Berg and us that they could have all of the work completed by the end of August. In our meeting, Mr. Berg had indicated to us that if we were able to get the work completed by the end of August, he would be willing to work with us. So our understanding as of that meeting was that we had a contract with Above and Beyond, which was what was asked of us. And then when we obtained the additional information that Mr. Berg had asked for, it complied with a date that Mr. Berg was agreeable to.
Or do you want to finish first? Or could I jump in?
Go ahead, that's fine, thank you.
We're jumping ahead to the forward, and this, somewhat of kicking the can down the road and a permission from the first inspection where you found the deficiencies. And somehow someone has, been dropping the anchor on you to comply, to fix these things. This whole situation to me is an epic failure. There ain't no other ways about it. And no one should be stopping you, another mother may I, to get things complied. I mean, what are you telling your residents? Hey, come rent here? I mean, I'll ask you that. What's your, what's your marketing pitch on that? Come live with us. We don't live up to code compliance for fire for 2 years. So a lot of this is a lot of noise to me right now. Who said, what said, who's pushing what cart? This is a failure to comply from 2 years ago. So everything else is kind of noise to me of who said, who's going to give you, and giving you all this latitude, and since you did do 4 buildings, to me, that's an admission that you failed the fire inspections, and you should be getting on it.
Sir, with all due respect, it's not an admission. We were threatened to have our certificate of occupancy removed if we didn't jump when the town said jump. So we took those
So
actions.
a threat got you to move, not the epic failure in the code compliant.
I understand your position, sir. I would just like to present for the record what
Go ahead.
our
I
version
won't
of the
interrupt you for a while.
situation. Thank you. So there's certain allegations that have been brought by the town with respect to Town Code 60-3. This is important because the Town Code Section 60-3 states Effectively, that the code enforcement officer must determine objectively that a parcel or property or structure may be found to pose a threat to the health, safety, and/or welfare of the residents of the town of Malta if it is in violation of the code of the town of Malta and any of the following conditions exist. And one of those conditions is 60-3A, a structure poses an unreasonable risk of fire. That is what has been alleged by Mr. Berg. To be clear, Mr. Berg's report does not state what violation of the code of the town of Malta we have alleged to violate. So we do not concede any alleged violations.
I think
and
it
we
was
would
a
like to set.
third-party fire inspection, not Mr. Berg, who was required to do the inspection, and failure happened in May of 2022. So what he says is just reiterating what a third party did.
Well, actually, the code requires Mr. Berg to make his own objective determination, and that's specifically written in 60-3. So Mr. Berg, for the purposes of this proceeding, is required to do just that on his own, and then present a report that delineates that. I'd also like to clarify that the 2022 report was prepared in May of 2022. Something the town has omitted from that is that there was a sundown provision that didn't take place until September of 2022. The town did not take any action in between May of 2022, which at the time of the report, which I urge you to read carefully, we did not have violations of glycol because as of May of 2022, there were no issues. The report that is in front of you from 2022 alleges different allegations than what is before you today. So I want to make that explicitly clear.
I'm going to read all of that, but it pretty much says Steeplechase ain't doing what they're supposed to do. I'm going to make that determination in a layman's term. And a lot of wordsmith of the town didn't do and who didn't do. I mean, let's not play games here. It's out of code compliant. A mission to me is buying extinguishers, fixing buildings, and you say you're going to get it done, or somebody's going to say it's going to get done, or there's some kind of contract out there without an end date, I'm not buying it. This is just kicking the can down the road, and a lot of wordsmith for an epic failure to comply with the fire code.
Sir, we're not kicking any can down the road. As we stand here before you today, we have a contract in place. The first payment has been made and work is going forward as soon as the vendor has received the glycol. We have said that.
Do we have a copy of that contract?
I had submitted that to the town 2 weeks ago. I have copies here with me, and I'd be happy to provide them to you all.
Without reading it right now, is there any punishment or liability if you don't comply with the contract? If the contract is what, to a vendor to fix it?
Sir, it seems like you have adjudged the situation before I've even put forward my evidence. So if you're telling me now that your decision is made, I would like to lay my record before this town board and for this
It's an easy
tribunal.
decision on my part, yes. Go ahead and say what you want to say.
Thank you. So the town initiated proceedings in town court, as Ms. Bitter had referenced, which is in violation of Town Code Section 60-4, which requires the town to bring these proceedings here. They did not do that. We had asked for a very brief adjournment to work out these issues with the town to avoid ever wasting the town's time before going to town court, before coming to before your board. We wanted to work this out. We wanted to come up with a plan to make this right, because frankly, we can't pick up our buildings and move them to another town, but it's been made painfully clear to us that the town of Malta has decided exactly what they need to decide about our client without giving us the opportunity to set forth our evidence or really allow us to proceed with our own due process rights. And after we had requested for a very brief adjournment in town court before our initial appearance, I was told by counsel for the town that I had 1 hour to have my client commit to a 6-figure contract, and then they would grant me a professional courtesy extension of time. That was 1 hour. We had 1 hour to have my client do that. It was a horse trade for a professional courtesy. Shortly thereafter, I had mentioned on that same call that I would contact the court and I would ask for an adjournment of the proceedings briefly because we had been retained 3 days prior to that proceeding. I was told that Justice Sloat wouldn't like that very much because he's already fed up with my client. So before I've even stepped foot in the town court, I now know that the town and the town's attorneys have had ex parte communications with the judge who is overseeing our proceeding. So there are no impartial proceedings that our client will be afforded in this town, and that's been made clear. And that wasn't the first time that ex parte conversations between the town's attorneys, and Justice Sloat occurred. Following our first appearance, at which Justice Sloat told us that we were not going to be allowed to put forward any evidence in our defense, that we were not going to be allowed to retain an expert, such as Mr. Ross here, to identify whether or not we even violated the code, we were told, no, you don't get any time to do that. You don't get to have a defense in this case. A week later, we made a motion to dismiss under the town code provisions that say that proceeding was not allowed. So after we made our motion to dismiss, the town indicated that they would agree to dismiss the town court proceeding and proceed under the code, which was here in front of the town board. And so we agreed. We'd be happy to have a discussion with the town prior to the town board meeting, which would have been offered to us. And I had a call on April 30th with counsel for the town, who indicated they would be discontinuing the town court proceeding. And they also told me that Justice Sloat had reviewed our motion. Somehow they knew that in the court, where our motion to dismiss had already been pending, what the town justice's opinion would be, even though he was the justice who would be overseeing the decision and ultimately deciding the fate for our client. So those are more conversations that had been occurring with the town's attorney, and the judge without me or my client present. Sorry.
It's not funny. It's not funny. You're sitting there laughing.
I'm laughing because.
You're laughing because your firm had ex parte conversations with the judge and you bragged about it.
Can I explain?
I'd like to finish my outline,
Well,
please.
consider you just, questioned my ethics.
I told you that on the
Did you
phone.
see Judge Sloat when you walked in this evening?
No, I didn't.
Oh, because he's usually here every town board.
Oh, I
meeting.
know.
And the reason he was here in that open meeting is because it was advised in the open meeting that the motion to dismiss had been presented.
And you understand, right? The rules of ethics.
Because I've never questioned somebody's ethics.
I doubt
especially at a
that.
town board meeting. So carry on.
That's fine. You bragged to me. You bragged to me on the phone about your conversations with the judge.
I got a quick question.
Wait, hold on a sec. If we could get back to, this is not the proceeding before Judge Sloat, right?
Correct. I would just
And-
like to continue to lay the record, and I will happily move on from the side conversations.
Okay,
Just like we did so far.
Yeah, I mean,
all right.
this has been
Frankly,
years for a phone call and agreement when to get it done. And it still hasn't happened.
frankly, we are trying to
Met
move it
several
forward.
times.
The town has, you've laid your case. You've explained 2022, 2023. We fully disagree with the representations that have been made about us. But as it stands, we are ready to move forward with a plan. We are moving forward with that plan.
Got a plan now.
Regardless.
When is the completion date for your new plan?
The end of August, which is what we had communicated to Mr. Berg, who understood that and even told us he would be willing to work with us with that end date.
What happens if you don't
specifically.
make that one, August deadline?
Then the town can raise those issues with us and tell us what needs to be done. We have communicated with Mr. Berg.
You don't,
We've
wait,
explained.
what, that question you just says the town will tell us what needs to be done. Are you asking us not to
No.
tell you what needs to be done at this point in
Nope,
time?
I'm telling you.
Holy smoke.
No, sir. What I am saying is that there is a procedure in place. August is when the next fire inspection will take place. Mr. Berg has informed us that if we can get the work done by the end of August, as our vendor told Mr. Berg himself, that they will do the inspection at the completion of the work at the end of August. If there is something that turns up in that inspection, the town can proceed in enforcing any alleged violations in any way that they see fit. And Mr. Berg himself said, after the work is completed by Above and Beyond, his words were, there'd be a clean slate. That is what we're asking for.
That's
We
our-
are proceeding.
That's our position.
Why don't we let her finish her outline, and then I think she has, Mr. Ross, you want him to contribute something? I'd like to finish hearing what you have to say.
Thank you.
Let's try to let her finish.
I appreciate that. Thank you. On May 7th, we received a notice to come to the town board meeting today. And in that notice, what was attached to it was a May 6th resolution from the town and the November 2023 order to remedy. Upon review of the May 6th Town Board meeting minutes, where the resolution was adopted by the Town Board, the allegations are that my client violated Fire Code NFPA Section 13 and 25, and therefore violated Section 60 of the Town Code. We don't know which specific provision of NFPA Section 13 they are alleging we have violated because there are 32 chapters of Section 13. Each chapter has various subsections. Some of those chapters have subsections as many as 35. Section 25 of the NFPA has 16 chapters with several subsections too. The point I'm trying to make by referencing this is that we are asking for due process. We are asking for the opportunity for the town to present their case as they're required to do under the town code. And the only reason that we even have to do this today is because we had come to an agreement that the end of August would be sufficient to the code enforcement officer, and yet that's not what their attorneys had represented to us. We are just asking to proceed as Code Officer Berg had asked. Continuing, there are some issues with the May 6th Town Board resolution that I need to raise as well. In the Town Board resolution, it states that the Town Code Enforcement Officer has provided a report to the Town Board of his determination that the apartment complex located at 2767 Route 9 violates numerous provisions of the New York State Fire Code, Property Maintenance Code, Fuel Gas Code, Chapter 89 of the Malta Code, and that it poses an unreasonable risk of fire in violation of 60-3A. None of that is included in the report that Mr. Berg submitted to the town. None of those are articulated in the town board meeting minutes from May 6th, and there's nothing that outlines the New York State Fire Code provisions, the Property Maintenance Code provisions, or the Fuel Gas Code provisions we are alleged to have violated. There's also no reference to Chapter 89 in Mr. Berg's report. There's strictly a reference to 60-3A of the Malta Town Code. The town board also claims that they reviewed a report setting forth violations that 20 apartment buildings were in violation of all of these codes. We haven't seen a report that says that. The only report that we've seen, which we just received on Friday when we had to ask for that report because it was not otherwise provided to us, is a one-page letter from Mr. Berg attaching a timeline of the allegations that Ms. Bitter walked through with you earlier today. The report that had been submitted to the town board is a one-page letter and does not contain the allegations that are listed in the May 6th resolution. Unless there's another report that has not been provided to me or my client, we do not see that Mr. Berg has prepared a report as described in this resolution that brings us here today. Further, the resolution claims that we violated the zoning code. Section 60 of the Malta Town Code is part of general legislation that is not in the zoning chapter, and there are no allegations of zoning violations. And I want to make that painfully clear in the record that there is no evidence supporting that any zoning violations have occurred. Further, the town board resolved in this resolution that my client is required to ameliorate the alleged violations in Mr. Berg's report. However, Section 60-4 of the town code specifically states that the town board may only make a tentative resolution, and only after this hearing can they require us to do anything. Further, to the extent that in the resolution there's any allegation of a violation of Chapter 89 of the town code, it's very clear in the town code, Chapter 89, that any enforcement of that must be taken in the Supreme Court of the state of New York, not before the town board. Further, Town Code Section 60-3 requires that the code enforcement officer objectively determines that a structure poses this risk. He also has to determine that the other following conditions exist. As it stands, we only have half of that equation. We only have an allegation of an unreasonable risk of fire. We don't have an allegation of what violation of the code of the town of Malta is before us. Not only is it our client's position that Section 60-3 of the Malta Town Code is unconstitutionally vague, but Mr. Berg has also not provided a report to the town that we have seen that includes with any specificity what the alleged code violations are. Further, there's deficiencies in the May 3rd report from Mr. Berg to the town board. The May 3rd report from Mr. Berg states that there's supporting paperwork. We don't know what that is. We did not receive supporting paperwork, but it appears that it was intended to be annexed to his letter, which I did not find. The only report we have is this one-page letter that references 60-3 and a timeline of events. The report also mentions that 20 buildings are in a condition that poses a risk to the threat and the health and safety and welfare of the residents due to unlisted glycol. And it also states that to date, all repairs have not been addressed and there's no anticipated date of completion. For the reasons I've set forth earlier, there is an anticipated date of completion. We have corresponded with Mr. Berg on that point, and at the time we did that, he seemed agreeable to our date. Further, the town and Mr. Berg have alleged in this alleged report that there is, quote, nothing but lip service and delays. Again, we have been communicating with the town since December of 2023 to try to remedy the allegations in the order to remedy from November of 2023. There is key components of this timeline that have been omitted by the town. The town did mention that fire extinguishers were purchased. They accuse us of doing that as a about face just to get away with whatever they're accusing us of getting away with, as if we want to be getting away with anything. We don't. That's false. Mr. Agins had asked us to do that until we hired a vendor. We did that at the request of the fire marshal, and we did that with his coordination so that we got the appropriate type of fire extinguishers. There seemed to have been a delay in communications after January when we asked for certain plans to set forth, whether or not we could even do that. There was a complete gap in time between January and March after the last correspondence, which you'll note, our last communication was from us. We went unanswered until March. And as I've mentioned before, that we had the May 16th meeting. We provided the town with a copy of our contract. We informed the town that we were going forward with this work. We informed the town that we had paid for that first payment that's required under the contract. We had informed the town that we would obtain any additional information that they needed from us. We informed the town that we would have an open line of communication between Mr. Berg and Mr. Tracy, our Director of Operations. We have acknowledged that there are some allegations on both sides that folks did not answer or did not respond to communications. We have made our guarantee that we will continue to improve our communications to avoid ever having to be in this situation again.
Can I just ask a quick question? When do you expect this repair work to actually start?
We anticipate the work to start as soon as Above and Beyond receives the glycol. They have placed the order. They have been paid to order the glycol. As soon as they receive that material, they have the green light. Work is going to go forward as soon as they can. The town has communicated with Above and Beyond. The town has communicated with our expert. The town has contacted every person that we've ever had any communications with because they want to verify what they want to verify. We haven't objected to that, and they are very much aware of who Above and Beyond are, and they've spoken with them. And they seem to trust that Above and Beyond is a reputable company to perform the work, and they haven't given us any representation otherwise. But we do understand the town has a preferred vendor of Absolute who they would prefer that we use at 3 times the cost of Above and Beyond.
So let me just interject to ask, do you care who they use, Above and Beyond or Absolute?
I think the assumption, and I don't mean to speak out of turn, was if Absolute identified the deficiencies, then that would be the most, efficient to utilize. So without having any communication otherwise, we had assumed that would be the vendor of choice.
But Above and Beyond is fine with you. Just another clarification. I mean, because it's an unlisted substance, the National Fire Protection Agency, and what's NFPA stand for, says that you can't use this substance, that it needs to be replaced. So we all agree here that this fix needs to be made, correct?
And we agree that this is being made.
Okay.
But we're not conceding any allegations that the town has set forth. We are performing this work to avoid any further harassment from the town.
Let me,
Okay, well, harassment's kind of strong. We're concerned about the health and safety of our residents.
Certainly, but the town has gone out of their way to contact our lender to send them notices, which they have no obligation to do. They didn't tell us that they were going to do that.
I beg to disagree with that. Legally, we're required to notify by law and case decisions, anybody that has a vested interest in the property and a mortgage holder specifically is required to be sent certified mail.
Is that in the town code?
It's in case law interpreting town law, section 13016, and our town code, section 60, chapter 60, is in furtherance of town law, section 13016. It's a legal requirement, and since we're also talking about other issues that has been represented that the town has not done properly, our town code provides specifically for the procedure for amelioration that Mr. Berg was required to make a written or oral report of his conclusion and the facts leading to the conclusions. He did appear, as he noticed before, 2 weeks ago, and made that oral report as well as substantiated it with the findings of the other reports. The attached order to remedy also specifies further what the violations are and numbers them and specifically enumerates what the problems were. That was back in 2023, all of which was provided. They've had multiple conversations with special counsel as well as Mr. Berg being present. To now say they're unaware of what the violations are is, I understand they're trying to add confusion to the record, but legally, Mr. Berg did file the town code, and we are required to notify the mortgage holder. So I just want the board to understand that. Thank you.
The other question that I have is, are your residents aware of the fact that they're in a potentially dangerous situation?
The town has taped up notices at the residences
Well,
to make
they-
it painfully
Right,
clear.
but they took them down rather quickly. They didn't paper all of the buildings. They started to do something and then were ordered to stand down, so
Well, it sounds like you have the answer to the question already that
what, well, that's what I want to know. Has anybody notified the residents that they're in a potentially dangerous situation?
I don't know the answer to that. Sir?
From
I'd like to say something.
the property.
When you gave them the
sorry.
fire extinguishers, why did you say you were giving them fire extinguishers? Just, hey,
I
have
think
this?
that's not that uncommon to have a fire extinguisher in a rental apartment. Mr. Warner, did you have a question?
Yeah, my concern that you're saying that you didn't understand the codes that were in violation in last correspondence. If you didn't know what they are, how can you today sign a contract saying that the end of August is when everything's gonna be rectified if you don't know what the codes are that are in violation?
Sir, I understand your question. I think our distinction is our argument that this was procedurally deficient versus what is proceeding separately. Those are two, I think, separate issues, and we're just trying to protect our rights given the way things have proceeded.
We're trying to protect the rights of the town and the people that are in town and their safety.
You know,
That's-
yeah, procedurally deficiencies don't really seem as important to the fact that, you know, you have 235 apartments that are potentially, well, fewer than that because some of them were fixed. I guess I don't understand why you started the repairs and 4 buildings were done and then you just didn't continue. I mean, had you been, had Silverman Group been continuing to make the repairs all along after you did the 4, we wouldn't be sitting here today because by now they'd all be done. stop?
Unfortunately, that's not true, and unfortunately, we didn't stop. The first set of buildings were completed, I believe, in April.
Of 2024?
Correct. And in April of 2024, we were brought to town court. When I was brought in, my firm and I were brought in, we had asked for an adjournment of 30 days to figure out what the town was alleging and try to come up with a resolution. We were denied that request. Then I asked for 7 days, denied that request too. Was given 24 hours. So just to be clear, the work didn't stop, but once we got sued, the landscape
I think
changed.
the better question is, okay, wait 1 second. You said they finished, I got a few here. You said they finished in April.
Yes.
All right. When did they start those 4 buildings?
I don't know the date that they started those 4 buildings.
Wasn't May 2022, August 22, I gather. But I commend you. It seems like a lot more effort and has gone into the defense of the procedure than it is to fix the remedy of the problems of the building, Jennifer. I give you that credit.
Sir, with all due respect, we want to fix this. We want to move forward.
I'm giving you-
Again, without
I'm
conceding
giving you
this.
credit on that.
Appreciate that,
But
but
I-
the town's attorneys don't seem to want to work with us. The town does.
Oh,
Mr.
listen,
Berg seems to want to work
Don't
with
get me
us.
wrong, let me get on the record again. This is an epic failure. That's my position.
I know,
all right?
you've
That's-
mentioned that many
That's the
times.
premise, yes. And I'll say it every day until they're all fixed. And the next thing is, it's very convenient when you quote Mr. Berg said, Mr. Berg is the authority, Mr. Berg said, and then next sentence, he omitted this from the legal brief. He omitted this from the legal brief. So cherry picking about what Mr. Berg said, he says it as it's the law, and then the next sentence you're saying what he omitted is therefore we're gonna, mention that statute to use against him.
No, actually, Mr. Berg had a conversation with us last week. We really thought we wouldn't even need to be here today because we thought we had the same agreement that Mr. Berg did.
Come on, this has been going on for 2 years. You didn't need to be here.
That's fine. We're very, very well aware this has been pre-adjudged well before we even walked in the door.
I did not prejudge the failure of the fire code on that building because I didn't know it until it happened. So I didn't prejudge a failure of the fire code. So to keep saying I prejudge something that I had no knowledge to until it was brought to me, and I'm in the maintenance world, after 2 years, it ain't prejudged, it's a fact that it's not completed. So there's no judging here. The fact is, it's taken 2 years, and we finished the first 4 buildings in April. So don't put words in my mouth, and then I'll get upset about that I prejudge.
Sir, you had knowledge and information before we presented our case, and you decided that our client was guilty before we presented our case.
No.
That is what I'm saying.
Well, I would just beg to read our statute. They're complying with it. There was a tentative determination. The town board is required by Malta Town Code under 60-4 to make that determination upon Mr. Berg's presentation to the board. That was done, and as I previously stated, we notified you, we notified the owner of the property, and pursuant to Town Law Section 130-16, we did the other 2 things that are required. For a notice to be served upon the owner's executives, legal representatives, agents, as well as any other person having a vested or contingent interest in the same. And as I explained, that's been deemed to be a mortgage holder. And also, the last sentence, for a copy of such notice to be posted on the premises. The town board was following the law in trying to get this matter corrected, and still, as their town attorney, that's what we're trying to do, and I think the board is asking for that. So the only other thing that I would say is, at this point, do you have anybody else you want to put forward to speak, or Ms. Bitter, do you have anything further?
We do have a few questions for Mr. Berg that we would briefly like to ask.
Fantastic, thank you.
You want to have him stand up here?
Before she does that, I just want to identify, all these documents here was what was before Judge Sloat. So this is what Judge Sloat read, so that he became very familiar with this decision. The conversation that I had with Jennifer when she asked for the adjournment, I said it wasn't up to me. I said it would be up to Judge Sloat. And at that point in time, let me speak, because I'm a middle child, so I can handle people questioning my ethics. And as an attorney, I cannot. This was what he knew. So he was well aware, and everyone here knows Judge Sloat, and he never comes in unprepared.
Nope.
So that was the discussion I had. The follow-up I had is when she was in the court, I said, if you just gave me a contract, we wouldn't have to do anything further. And I think everyone that was there would see that that was true. This is the contract that Mr. Berg was given.
And that was dated,
It's dated 5/3. It's the same contract you gave, right, Jennifer?
I don't know what you have in your hands,
Oh.
but our contract is from May, yes.
Yes, May 3rd. And it does state dates of like April 16th and such, so it was being put together. And then there's partial payments. That's how it's.
and the
It's been outlined.
agreement was to get it completed by
Oh, I'm sorry.
that contract in August?
No, there's no timeline in that contract. So she's correct in the sense that my concern at
So
that meeting was
I-
that there was no contract.
I guess I don't, what I don't understand is why stop? You know, I still don't understand that. Why start and get the 4 or 5 buildings done, however many it was, and then stop?
So we
Whatever the
didn't, and
proceeding
Ms.
for.
Bitter she just really explained that because we had the first set of buildings completed. The paperwork that she just hands you shows you that we had been talking to Above and Beyond in April. There is no gap in time. The contract was signed in May. We had been working with Above and Beyond. Frankly, I think we're splitting hairs at this point in terms of April 1st versus April 15th, because during that, April 15th and May 1st, the dates that are in front of you, those dates, I think that the distinction is really without a difference, because while we were also fighting in town court over this, we were talking to Above and Beyond about getting the work done.
Did you make that known at the time,
Yes,
court?
yes.
Can you ask
Happy
me,
to get the minutes from the transcript from Justice Sloat's court if that would be worthwhile.
So you have paid towards the total cost of $154,508,000. You've paid $46,352.
Sorry, what is the
The
508?
the purchase, the scope of the work calls for, including tax, full payment, it looks like, of $154,508. Is that correct?
That is correct. I thought you said
You've paid, and
508,000.
you've paid roughly a third of that, a little less than a third of that.
We have paid in accordance with Above and Beyond is common practice and what their contract calls for, yes. It's a staged payment process. You pay for them to order the glycol, they get the glycol in, we pay them, they do the work, we pay them. And that's rinse, repeat.
now, you said you didn't know the date that, they finished in April of the 4 buildings. Does anybody know the date when they started that work?
Man, how long does it take? Don't know.
If I could, though,
I-
excuse me, I would like to just add something to help clarify why there's an apparent separation. Yeah, sorry.
So for me to move on, I kind of need to know, because this is why it escalated to this point, and predeterminations and stuff, is that you're saying 4 buildings got completed in April, when this whole journey started back in August of 2022. So there, to me, is a gap, and some people may perceive it as a harassment as much as a concern, and being forceful of trying to abide by the town rules and laws. So do you know that date?
I don't, off the top of my head, know the exact date
Ballpark
that
me.
they started, but I think it took them maybe 2 weeks to do those, or maybe 3, to do those first set of buildings, although I don't have the
Listen,
date.
that's well within, even if you said a month it took.
Yes,
The
but-
start of this journey to where we are today is,
What I
that's the
wanna-
problem.
Yeah, I understand. What I want to, just a point of clarification about the perceived gap between when we started and why we stopped. The first set of buildings that we wanted to address were those with physical deficiencies beyond the glycol that we felt were in need of being addressed quickly, right? I think there were some risers that were rusted, there were some gauges, there were some valves that needed work done. So it made sense to us to address those immediate concerns first. And in addressing those immediate concerns first, also do the glycol where needed. So that's why that work was done right away, for a lack of a better word, or as quickly as we could get it
When
done.
you say right away, what day are you talking about, right away?
Not right away the way you mean it.
So
Right
you're saying
away, when I
within
mean-
about
when
a
I say
month,
right
a month and a
away,
half.
I mean at the point at which this, escalated in whenever, in April or whenever that is. But yes, so that sort of might explain why those buildings were done first, because there were also some physical problems with the piping that we wanted to get at right away.
So what guarantee do we have that, that you'll actually continue with this contract and make the next payment, and that by August, all of these buildings will actually be put in a safe situation?
So in the meeting that we had last week with Mr. Berg, Mr. Eggins, and Ms. Bitter, I indicated that, and I mean it, we're going to, when we start this in earnest, we're going to continue, and we're not going to stop until it's over. I'm not a lawyer, and I'm not a fire protection engineer.
Neither am I.
But I made a commitment to them last week, right, that, there were for whatever the reasons, and, at the beginning of this, that caused the delay and upset everyone here, right, which I, quite frankly, can understand. When our property manager, who is relatively recently posted at the property, became aware of the conditions, she escalated it immediately. There was a time frame between the time that she escalated it and I got eyes on it and became involved with this, at which point we immediately started to make plans to remedy the issues and concerns. And again, once we begin this work, I don't plan to stop the work until it's completed.
And I appreciate that. I mean, one thing that really concerns me is that, it's been 2 years since we were first made aware of the situation. I mean, I don't know if you were even with the company at that point, but it's taken 2 years to get to the point where anything is being done. So I appreciate that you're.
It's understood, and yeah, I'm not here to make excuses. I'm really just here to I wanted to come up here to just let you all know that we have every intention of doing
I appreciate
what's
that.
right for what's right for our residents and the community in the town, and to follow through with what we say we're going to do. And again, I'll just reiterate what I said last week.
So can we get a signed contract?
I'm sorry?
Can we get a signed contract that it's gonna be completed?
Yeah, I guess that's what I want to know. What's our recourse here?
Yeah, starting dates are much easier to ascertain than completion dates, right? So as was requested last week, I reached out to our vendor because I couldn't commit in person to a completion date because I'm not doing the work. I don't know what hurdles there might be in the way, unforeseen conditions, whatever. So I committed to them that I would reach out to our vendor that day. So, we drove back to New Jersey and I got right on the computer and I asked him, please provide your best estimated completion date for this work, which he did. And I made sure that Mr. Eggins and Mr. Berg were on that correspondence so that they could see, it's not like I wasn't passing along the information. I was sharing it in the email with them so that they would see the same email that I saw. Anyway, so I think it's.
If I may briefly interrupt,
Yes.
we have copies of that communication for the board's consideration that I will put up here. That indicates what Mr. Tracy is explaining.
And it's signed by all parties?
It's just emails or something.
It's a contract between CNR Property Management and Above and Beyond.
Well, I'm not going to I hate to do math in public, but if it took 2 weeks to get 4 buildings done, that leaves only 20 left to finish by August. I see that as an obtainable goal if everything goes to plan.
As do we. So we're just adhering to what our vendor indicated it would take him. And yeah, so, we expect that if he doesn't run into something crazy out there that he didn't expect, right? Some problem, or, perhaps a delay in the glycol shipment because of, supply chain issues or something like that might cause a problem, we think that it's achievable as well. And again,
We are very reasonable up here. We've waited 2 years. We can wait another 8 weeks.
All you gotta do is get on the phone and call Greg, saying, hey, there was a problem with a shipment, with glycol.
Yes.
Or
Of course, and I think he and I have that understanding now.
just keep the door open though.
Yeah, he and I have that understanding now, I think, based on our last meeting, that, from here on out, there will be full transparency in all of our communications. And, again, we really just want to get this work done.
I just want to go back to, I think someone else asked this question, but do the people who are living in the apartments that have not yet been repaired or their fire suppression system repaired,
Yes.
are they aware that they are at any risk?
I don't know of any communication that's gone out to them, although there could have been at the local property management level. But I'm unaware of a communication that's been issued.
I'm an old lady. I have children, I have grandchildren, and I ran for this job because I care about my community. And what I don't want is to pick up a paper one day this summer that there's been a terrible fire with deaths. in this particular apartment or anywhere. I don't want to read about that. But
I understand.
we've all known about this apparently for some time, and I'm a simple soul. I just don't understand how you can live with yourself. I would be so upset if an apartment, and I have at different times in my life been in a small way a landlord, if something I could have prevented caused death or harm to one of my tenants, I could not live with myself. I look out in the audience and I see some neighbors, Malta neighbors, who are volunteer firefighters. They put their lives on the line every time they get on a truck. And to go to a 235-unit apartment building that does not have the correct kind of suppression system in it now, I'm looking at those people and saying, you know, I really don't want to go to their funeral, to their hospital bed, to console their wives, their families. It's hard enough to get volunteer firefighters these days, but to ask them to go to something that our town has been aware has been a problem for 2 years is really tough for me to get around. And I'm hoping that you will do the right thing and let people know that, I mean, like, for example, how many children, do you have any idea how many children live in those 235 apartments?
I do not.
Are there some?
Yes, there are some, because I see the,
I would imagine there are, but
There
I
are some
don't know.
children who live there. Are there anybody, is there anybody who is physically handicapped who live in those apartments?
I do not know.
Who might have difficulty getting out of an apartment in a fire?
I do not know.
So,
Well, I think Ms. from Mr. Berg, is that correct?
oh,
I think no, thank you.
Is there,
hopefully this doesn't happen in the future over and over either. It's costly for you, it's
You can make a
costly for us, and it's a safety hazard. That's simple.
I understand, sir, and believe me, I do understand your concerns. I have kids myself, and I just, again, I want to reaffirm and reiterate that now that we're here, we would like the opportunity to begin and continue the work to completion so that we can all, start with that clean slate we talked about last week.
I have a suggestion that I brought to Mr. Gottman's attention.
yeah, real quick before that, but that's also the spirit of, as late as Friday, there was communications between the parties to see if the matter could be adjourned. I mean, I know things can get heated at meetings, and I appreciate you coming in and clarifying your position. And I think the town board's hearing a lot that they want to hear, which is that, I can't speak for them, but that you intend to complete the repairs that are required. And they seem to be asking for, assurances that it's going to be done, and I think that's what Ms. Bitter wants to comment about.
So, understanding that they have this contract in place, appreciating that, I think we can all agree, and I'm hopeful that Mr. Tracy and his team will agree, is that the deficiencies that are outlined in the absolute report of August 23 are what they're going to correct, and that I would suggest, if all are agreeable, to adjourn this matter until August 30th. I don't know what your next town board meeting is in August.
Well, it would be the last Monday of August. What, are we having a Monday meeting?
That way we can obviously make sure that there are communications between the parties, and that if the work is delayed for some reason, that Mr. Berg is informed, so that he can then advise the town board. And if we have to come here on that last meeting to advise of the status, then that way we have an opportunity and we don't have to redo this.
I would just ask that, of course, that, you keep Mr. Berg, informed of the progress, and that then in turn, Mr. Berg makes sure we have regular updates about that the work is continuing to be done. When they get the substance, when you start with whatever they have, are they ordering enough of the substance to do all of the buildings at this point? Or did they just get some to do some, and then you'll have to wait for more? Or
Yeah, so we will be staging the work, right? So we're going to be doing it in 4 stages, but they will be contiguous stages.
Okay. Is that
Ms. Yeto, is that something you think is acceptable to you and your client, that we just adjourn it? The benefit to this is we've had a hearing. If anyone else wants to comment at the hearing, they can, but we can adjourn it.
Yeah, well,
Give you
let's-
the time to complete the work, which is what everybody wants, and, with no further proceeding unless the work isn't completed.
Well, I might ask, is anybody else out there in the public have any comment that you want to make regarding this? Okay, seeing no one, we'll,
Wait, before we finish with that, Ms. Yeto, anything further from you and your clients?
We are willing to adjourn this until the final Monday in August, I believe is the date of the town board meeting.
Correct. It's a agenda meeting for August, and typically is the final Monday. We'll verify that for that date, and we'll go from there.
Great, thank you very much.
Thank you.
Thank you all for your time.
thank you.
Ms.
So,
Young, close the
Well,
hearing.
then we'll, do I have to have a
Adjourn the
motion?
hearing?
To adjourn
No,
the
you don't
meeting?
have to have a,
Okay. Then we'll adjourn this meeting until August, and hopefully we won't have to see you before then. Because the work will just proceed and everybody will be happy.
Thank you very much.